legacy, today's conversation promises to be both insightful and thought-provoking. In the fiduciary landscape, a poorly drafted will or the mishandling of its custody doesn't just create administrative headaches, it can cause emotional distress, family conflict, financial losses, and legal disputes that can last years. Today, we'll be discussing real-world challenges and costly mistakes that can arise from inadequate planning, and more importantly, how they can be avoided. We are fortunate to be joined by a panel of seasoned professionals who will unpack this topic from both legal and practical perspectives. Guiding today's discussion is our moderator, Sarah, an accomplished leader in the financial services industry with over 18 years of experience spanning banking, insurance, and fiduciary sectors. Sarah brings a rich blend of academic excellence and practical expertise, holding diverse qualifications in wealth management, insurance, and strategic leadership. Beyond her corporate background, she is also a registered industrial and organizational psychologist, a current PhD candidate, and president of the prestigious Top CEMS Club, which celebrates UNISA's top 100 performers. Her holistic understanding of both human behavior and financial systems makes her the ideal person to steer this conversation. Joining Sarah today are two experts in the fiduciary field. Firstly, we have Delon, a qualified fiduciary, estates and trust practitioner, and currently the head of advice and fulfillment at Absa. Delon's career spans over 18 years in the legal and financial services sector, including roles at Standard Trust, Discovery, and now Absa. His expertise include domestic and cross-border estate planning, the formation and administration of trusts and companies, and high-level fiduciary strategy. He brings both legal acumen and entrepreneurial insight to the panel. Also with us is David, an estate manager at Absa Trust Estate Services. David has over 7 years of experience in the fiduciary space and has handled a range of high-profile and complex estate matters. Sorry, can I just ask everybody to be on mute? Thank you very much. He holds a law degree from the University of Pretoria and has developed a deep understanding of estate administration through hands-on experience. We are in for a dynamic session, so I encourage you to engage with our panel by popping your questions in the chat throughout the session. Without further ado, I now hand over to our expert moderator, Sarah, to get us started. Thank you, Sarah. Over to you.
Great, Verity. Thank you so much to you and your team for helping put this webinar together. And a very warm welcome to everyone. Just like to welcome you to part 2 in our part 3 series. Today, we're going to look at the topic, when wills go wrong, the cost of poor drafting and unsafe custody in estate administration. For me personally, this is such an important discussion because while many people think or look at the value of having a will, there are fewer people who realize the risk of when a will is poorly drafted, it's outdated, or even stored unsafely. And the consequences of this can be really devastating for families. And personally, I see this all the time. I get complaints that land on my desk. I speak to people and they're in destitute places. And unfortunately, they tend to blame the system. They tend to blame the process. But all of this goes back to a will that was not drafted properly. We are fortunate today to have both will specialists and estate team with us today, and they'll help us unpack the pitfalls and share the real life examples and offer practical solutions. So without further ado, I'm going to start with Delon. So to start off with, I want us to focus on why a will matters. A proper drafted will ensures your wishes are respected, while poorly drafted or missing will create serious challenges for families, right? So, Delon, I just want to hear from you. Could you just maybe share with us about a well-drafted will? Why is it essential, and what happens if it's not?
Good morning, Sarah, and good morning to the viewers today. Sarah, absolutely. A valid will or a well-drafted will is more than just a legal document. It's a roadmap for your loved ones. It clearly outlines your wishes and ensures that they are legally enforceable, giving you peace of mind that your estate will be handled as intended. So when a will is missing or poorly drafted, it can trigger delays, family disputes, and emotional strain during a already difficult time. So legal complications often arise and outcomes may not reflect what the person truly wanted. So in short, Sarah, a well-prepared will protects your legacy and the people you care about.
Thank you for that, Dylan. And I mean, I can never overemphasize that. And I mean, you've touched on that. It leaves your loved one behind in a destitute place, and it's quite critical that we have it right. But I want us to look at the common drafting mistakes that we see. I mean, these could include unclear wedding, failure to meet legal formalities, or even leaving a crucial clauses like guardianship. It could be outdated wills that don't reflect major life challenges or cause major life issues. So, Dylan, just take us through some of the drafting errors you encounter most often and the impact that has on individuals, on families.
Certainly, Sarah. So drafting will is a delicate process, as I alluded to, and small mistakes can have big consequences. A few common pitfalls that I come across in my experience is, like you alluded to, unclear wording. So vague terms like my belongings or my estate can lead to confusion and disputes. It's important to be specific, especially with special assets, and to name backup beneficiaries in the case your first choices can't inherit. I think you also pointed out failure to meet legal formalities. So again, Sarah, a will must comply with the Wills Act 7 of 1953. That means proper signatures on every page signed in the presence of witnesses. A frequent mistake that comes across my desk is having beneficiaries sign as witnesses, which disqualifies them. This also talks to when people look at DIY wills, which often miss these details. So legal guidance is very key to these.
Sure. And what are some of the, I mean, we spoke about omitting clauses as well,
Mm.
guardianship. Can you also maybe take us through that as well?
100%, Sarah. So many wills leave out vital provisions like guardianship for minor children or testamentary trust. Without these, obviously the courts will then have to decide who will be the guardian of your children, and your children's funds may end up in the guardian's funds, which can disrupt the person that's making out their wills, their true intentions for how the children should utilize those funds. You also have other common pitfalls such as outdated wills. And again, something that is commonly missed is life changes, Sarah. So, like marriage, divorce, or the birth of a child should prompt updates. For example, after a divorce, you have 3 months to update your will, and if you don't, your ex-spouse could still inherit under that legal valid version of your will. Another pitfall that I notice, and goes to poor planning, is not accounting for marital regimes that can lead to legal challenges. If you are married under the accrual system, for example, your surviving spouse may have a claim against your estate, and failing to plan for this can cause liquidity issues and delays in your estate administration.
Yeah. Thanks, Dylan. And I mean, I remember specifically a case like that where people forgot, somebody got remarried, didn't update a will, passed on. And it really took us time to go through that estate administration because there were so many complications. The new wife was not part of the new will, and we don't know whether these were the wishes of the deceased or not. So that's
Mm.
quite critical. Thanks for sharing that, Dylan. Um, so looking at the common mistakes is just one story, right? In terms of drafting the will. There's also the other part, which is safe custody. So, and I know in this webinar, we're talking quite high level. There's multiple stories that we could share. And I think for me, this is where we say, we come in and say, use your professional, because then they're able to share all this information with you. But looking at safe custody, Dylan, because that's equally critical as much as drafting the will. Wills kept at home could be lost, it could be stolen, it could be deliberately withheld in times of conflict. And having multiple version also adds further confusion. So could you just
Mm.
maybe take us through the risks of unsafe custody and why proper storage is vital?
Oh, definitely, Sarah. So even the best drafted wills is useless if it can't be found or verified. Wills stored at home are vulnerable to fire, theft, or being deliberately withheld during the estate administration process, which can cause family conflict. That can delay estate administration and cause unnecessary stress once again for the families. Multiple versions without a clear copy can spark legal battles, and again, this could prolong the estate administration. And without proper registration or safekeeping, like storing with a fiduciary institution, retrieving the will from the master's office can take weeks to get a copy validated by the courts. Safe custody isn't just about logistics, Sarah. It's about protecting your final wishes. Institutions like Absa Trust do offer free drafting of your will. And of course, we do offer the secure storage of your will as well, ensuring that your documents are both legally sound and accessible when required.
Yeah, and I can tell you, Dylan, I mean, there's nothing as painful as a will is drafted. It's a proper will, but we are now stuck. We have heirs that are sitting there or next of kin that are sitting there. They don't know what to do. They don't know where to find a will, and it really causes serious problems. So one can never overemphasize the importance of that. So just to recap again, Dylan, one, we spoke about the importance of having a will. You then moved to the importance of having a properly drafted will, but also moving into safe custody. So all these things are interlinked. It's not just about drafting it, or it's not just about having a will. It must be kept safe as well. But understand the risks that are involved there. If you do not ensure that your will is drafted, it's kept safely, you leaving your loved ones in a messy place, and that's not really what you want to do. I guess your intention in drafting a will is to ensure that you leave them in a better space.
100%, Sarah.
Yeah. And I just want to move now into like the real practical examples, right? So when wills go wrong, it's not just a technical problem. It's got deep impact on families, as I've just indicated. So a contested will often delays the letter of executorship. It can create uncertainty and escalate costs as well. David, I just want to come to you. Could you share some cases where you've seen where a poor will had a major consequence?
Thanks, Sarah, and thanks, Dylan, for explaining the importance of adhering to the formalities of a will and actually storing it safely after having prepared. We come across a lot of cases when the matter comes to the estate administration department. At that time, the owner of the will has passed away, and it's sad to realize at the time that the will is not properly drafted because the matter cannot be rectified. We've come across a number of cases where some we can resolve easily, but there's some that can put the estate administration process to a standstill for an indefinite period and even passing on to the next generation. We recently had one estate that was brought to our office last year. It was prepared by a married couple who prepared a joint will, and in their joint will they nominate the first dying to be the beneficiary in that same will, the survivor of them. And when the survivor passes away, the assets are transferred to the children, to their 4 children, and they've got grandchildren. You can see from the way that they've drafted it that these grandparents love their grandchildren. They requested that we sell all the assets. That's the precondition to the will. We sell all the assets, convert them to cash, and open up a trust. The trust, we were instructed to pay for all the educational needs of all the grandchildren born at the time, born and alive at the time that the surviving spouse passes away. Now, that precondition goes on. It does not provide a timeline, does not provide a geographical area where the grandchildren can get educated. Now, this in essence, it postpones the inheritance of the children. You can see it says I'm bequeathing my property to my children after it's been converted to cash. Create a trust and take my grandchildren to school. Now, let's assume the youngest grandchild is 1 month old when the two testator and the testatrix pass away. It creates a problem. It actually postpones the inheritance by over 25 to 30 years because
Sure.
You can understand the grandchildren, all of them have to go through top-notch preschools, primary schools, high schools. All the extracurricular activities there are included in it. tertiary university, if these grandchildren decide to further their education, maybe obtain a master's degree and an advanced certificate in something, there is no limit to all of that. Now, the problem that we have is that the first one is, as soon as you sell the house and all the assets, the people living in that house, including the grandchildren, are rendered homeless. With the open-ended supply of funds for education, which is notoriously expensive today, we risk depleting all the assets in the estate. Now, to prevent this problem created by the preconditions of the will, the children of the deceased are not cooperating with us. They are refusing to provide information that will enable us to administer the estate. They're just holding on to everything and not playing along with us, because they can see the problem that they will face if we sell all the assets, pay for university fees for their children, and all of that, and I mean all the grandchildren. They realize that they're not going to get anything and they're not cooperating. Now, as the executor, we're supposed to enforce the will and look out for the interest of all the beneficiaries. That's the grandchildren and eventually the children of the deceased. It's a very difficult situation, because as the executor, I now need to, I can either now approach the court and enforce it and force a sale. Forcing a sale where you need now to evict the children of the deceased, it becomes a very difficult situation. This is an absolute stalemate that I don't see how we are ever going to resolve it. And this could have been resolved if maybe the deceased decided who he wants to give his assets. You can decide if you want to give your grandchildren, give your grandchildren straight. If you want to give your children, give them directly. In another file, this one it was prepared. It's a will that was prepared by the deceased. He's got his ex-wife, 2 children from his ex-wife. He's got a girlfriend and a child with a girlfriend. Now he prepares his will, and from the will you can tell he's got an idea of what he's doing, but he makes a catastrophic mistake in that matter. And how he does it, he instructs us. He's got a farm and 3 sectional title properties and some farm implements. He bequeaths them to his ex-wife. That's the wording of it. Now, bequeathing to the ex-wife, he directs us to sell the assets, all of them, and that from the proceeds of those assets, 300,000 rand is given to his girlfriend. That's the mother of his son. 5,000 to his gardener, 5,000 to his housekeeper, and the remaining 25% to his ex-wife and 75% to his 2 children. Now, this individual sold all these assets that he bequeathed to his spouse and the children and all of that. He sold all the assets. Now, when he passed away, we receive the will, we report the estate, and we learn that all the assets do not exist when we send our evaluators to do an assessment. There are other assets in the estate. There is cash from investments and other movables here and there. Now, that's all we have. Now, his will, with the way he had prepared it, it could not dispose of the new assets. And these assets that are given, we cannot give them to anyone because it does not have a provision for residual assets. Usually, when drafting a will, Dylan mentioned their failure to provide for residual assets. That part, if it was there, would have been able to give to the people that maybe he chose. Now, with disposing of these assets, it creates, it invokes a legal provision called ademption. This applies where a testator voluntarily alienates the subject matter of the bequest, and it is the presumption that we take is that he intended to revoke the legacy. Now, we had to deal with it with the remaining assets in terms of law of interstate succession, because the will that he left did not provide did not work sufficiently as an instrument to dispose of those assets. We had to deal with the remaining assets in terms of interstate succession. Now, in interstate succession, he's divorced. There is no spouse, he's got a girlfriend, and there's only children. So now all the 3 children, the 2 children from his ex-wife and the one child from his current girlfriend become the sole beneficiaries. Now, his ex-wife, his current girlfriend is automatically excluded, and the child of the girlfriend who was not in the will now benefits from assets that were not initially intended for him. Now, if he had worded that will a bit differently, would have been able to salvage it. For instance, if he had said, I bequeath 20% of my estate to my spouse, 20% to my children, or 20% in some other way, would have been able to work with it. But because it was a bequest, the will came in the form of a bequest of even the proceeds of those assets. It terminated the application of the will. We dealt with it as if the legacy had been revoked. And in another matter, it's also just an extension of how people need to apply their minds and imagine situations playing out when they prepare wills. One gentleman, he is married out of community of property, prepares his will and gives all his assets to his girlfriend. Well, it's fine and well. You're married out of community of property. You can do as you wish with your assets. Bequeaths all his assets to his girlfriend. He did not apply his mind as to how this is going to operate. The wife and children lodged maintenance claims, prepared actual reports, which were accepted as valid claims, and they depleted the estate. Now, this man, if he wanted to dispose his assets and accommodate his girlfriend, he should have applied his mind to see this kind of will I'm preparing. Will the executor be able to apply it correctly? And it has not worked. Right now, we are about to go to court. This one is actually a recent one. We're about to be going to court. I'm sure in the next few months, we'll be receiving papers from court papers from the spouse and the children, challenging us onto those claims, and eventually they will succeed in taking all the assets. I think I'll leave it there. Sarah.
Yeah, no, David, thank you so much. I mean, those 3 examples are quite comprehensive. I mean, the one that I gather, the last one, it created issues in that, he thought he had it right, but monies are bequeathed to somebody else purely because of it wasn't drafted properly. We can see in another example as well that there now is contest. I think the last one where now court is involved. There's objections and people are coming to claim in. And I think if I look at this holistically, there's a time issue. There's issue of disputes. There's issues of objections, which then delays the whole process itself. And David, thank you so much for sharing those, because for me, this is where we need to learn by hearing and understanding the real life examples of how your drafting of the will, the planning actually impacts the estate administration. And maybe before I go to my next question to you, David, just to say to everybody, you're welcome to put your questions on the chat. We are going to have ample time to discuss those questions post the discussion that we are having right now. So if you could just start by posting your questions in the chat. David, just back to you now. We looked at the issues that relate to, or examples that relate to poorly drafted wills. I just want us to expand this a little bit and look at how does it actually affect the broader estate administration. So if we look at, if you have without a valid or accepted will, estates can move forward, and families often wait months or even years for resolution. And I think in one of the first examples that you presented could be one of those. Can you just expand a little bit more on how invalid or contested wills actually affect the work of administrators, executors, and even the master's office as well? David, you're muted.
Sorry about that. As soon as anyone contests a will through the court process or lodge an objection with the master of the High Court, the estate administration process comes to a standstill until the objection is resolved or until the court resolves the matter. In our space, wills are usually contested for validity, where members claim that maybe the signature of the deceased is not on the will is not that of the deceased, or that the deceased was not of sound mind or capable of deciding in terms of the will due to illnesses or being intoxicated with medication, the list goes on. But if the court upholds the contest and sets aside that will, then that's the end of it. If the matter is not appealed through the court processes, the decision stands. That will is set aside. And it puts us also in a difficult situation, because firstly, it's time. From court processes take time. They can take easily between 5 to 7 years. Now, secondly, the disadvantage of such a situation is when a will is set aside, now we need to move back to the previous wills. If ever maybe the deceased decided to update their will and they don't do it correctly, then that will is set aside and we have to go to the previous wills. And if they did not have a previous will, we will deal with the estate in terms of the provisions of the Interstate Succession Act, where now other people who the deceased did not intend to benefit end up benefiting from his assets. And the other issue maybe is if a will is invalid, when we receive a will that is maybe properly that did not adhere with the provisions and formalities of a will in terms of the Wills Act, we will collect all the wills, submit them to the Master of the High Court, and the Master will assess them as well, and they will be the one to reject the will outright on that basis. Now, when a will is declared invalid, the next step would be for maybe the beneficiaries to approach the courts and try and convince the courts that that document was the final will of the deceased and those were his intentions. It has been done in one case. In this specific case, the will was not signed, but it was stored in a computer device that belonged to the testator. Now, this is a case of 2002. It's the case of McDonald versus the Master, where the court applied the condonation in terms of Section 2.3 of the Wills Act. We refer to it usually as the rescue provision, which allows the court to recognize the document as valid, even if it did not follow all the statutory formalities. But the requirement is, as long as it can be demonstrated in court that this was the deceased intended will, or he intended it to be his will, whichever the wording can check. In this case, it was found that the document drafted by the deceased testator in the form of a computer file would be condoned by the court, and this act of the court to allow a document that is not signed to become to be accepted as the will of the deceased, because the court was satisfied that the deceased intended it to be their will, was something in 2002 already looked as a progressive stance by the courts to accommodate technological advancements in relation to wills. And I think it may open us up to, in the future, using maybe digital platforms or much more advanced ways of drafting wills, especially in the way things are moving in terms of technology and artificial intelligence. I think the courts are going to be considering matters of such a nature in future. But the issue is, it's not just given by the Master of the High Court. It's something that you need to follow a court process and prepare voluminous documents and expensive legal fees for you to satisfy the court that this document that is not compliant with the formalities of the will is actually the will that should be taken and accepted as the final will.
Thank you for that, David. And I think from a time perspective, and I just want to touch, you don't have to give exact numbers, but sort of on average, right? So looking at the time aspect of it and the cost aspect of it, what's the longest time that it took because of a will not being properly drafted and it had to be contested and so on? How long can one wait?
The shortest I've seen was around 5 years, but that one was opposed. It's a different one if it's not opposed. Maybe it could be a year or two. But if it's opposed, it may go for quite a longer time, especially if there is disputes of fact. It may even be referred to a trial to have people come lead oral evidence and explain what issues that they know.
Yeah, and yeah, and you said that's the shortest time, and that's 5 years. I mean, in a straight-through process, estate where there's no complexities, we're looking at something between 0 and 6 months. Now, here with these complexities of an unsigned will or it's contested, we're looking at a minimum of 5 years. From a cost perspective, roughly what can one be looking at here?
In an opposed matter, it could go to 800,000 and beyond, depending on the number of days, if ever there is witnesses that need to move into the case and lead evidence. But we've received quotations of around 600 and 700,000. In the one that I'm telling you about of the husband who left his assets to the spouse, we received a quotation of 860,000
Sure.
for an opposed one.
Yeah. And I think for me, it was important to share that information, David, so that people understand. And I mean, the timing aspect of it, the cost aspect of it, because then this is something as well that could deplete the estate money. And that's not something that we want. So really, it is quite important that we get these wills well drafted. So we've spent probably the first hour talking about issues, talking about the problems in drafting a will. Um, but of course, today it's not only just about problems. We also want to be about solutions. So drafting with professional guidance, updating wills regularly, using safe custody services, and even digital tools can make a huge difference. I'd like to open up to both you, Delon and David, and just to take us through, what are the best practices and solutions you recommend to ensure wills are both valid and accessible when they are needed the most? So maybe to start off with you, Delon.
Thanks, Sarah. I think that's a great question. So, a few key practices stand out for me is number one, professional drafting. Work with fiduciary experts to ensure that your will is legally compliant and tailored to your needs. Absa does offer this through our qualified and professional legal advisors as well as financial advisors. Make sure that regular updates are done. So review your will after major life events, especially marriage, divorce, birth of children, or even business changes, just to keep it relevant in terms of your current circumstances. And I think we did touch on the point of safe custody as well, Sarah. So just store your will with trusted institutions. Make sure that your family and executor know where it's kept to avoid those delays as well. In terms of digital, Sarah, very, very good question. I think we are moving into that area where we are dealing with a lot of digital assets such as cryptocurrency, NFT, social media accounts, cloud storage, and digital photos. And these are need to be protected and distributed according to one's wishes. So they should be explicitly mentioned in a will with the handling instructions and beneficiary designations. I would obviously apply caution with the access credentials to the digital assets, and would rather suggest keeping these in safe storage for limited access and include where this can be found on death. This is also to protect the information, ensure that it doesn't fall into the wrong hands. And this is just due to the high number of fraudulent activities we as Africans experience. Sarah, while South Africa is a legal framework is evolving, the Wills Act does still requires a physical
Yeah.
signature or a wet signature and witnesses as well, for witnesses as well, excuse me, which complicates the inclusion of digital signatures on wills. But I think we are moving in the right direction. If you look at the regulatory bodies like FSCA, who are also advancing digital assets legitimacy by licensing crypto service providers, this will definitely assist us as we move forward in this process. From a wills journey point of view, Absa Trust is looking at enhancing our wills drafting through these digital platforms. But currently, we do have a digital direct wills journey, which allows a client to get their will drafted within 30 minutes of them giving us their instructions. And again, we have qualified people on the line to assist these customers to ensure there's reduced manual errors and just to ensure that their wills are intact. Thanks, Sarah.
Great. And I think that was going to be my next question to say, with us moving into the digital environment, how does that impact the estate planning and wills drafting? And you've actually touched on that. Thank you for that, Delon. Over to you, David. Do you want to just maybe share with us on your side?
My
Yep.
view, I think it lies with the draftsmen who assist the client with preparing the will. Important that they don't just accept the instructions from the testator and prepare a will to uphold the testator's freedom of testation. They should draft that with professional guidance and challenge that testator by playing out the estate administration process and highlight possible pitfalls that they foresee occurring after death of the person who intends to prepare that will. And I'm very happy with Dylan's digital plans for us. They will really safeguard some of these things and ensure that we do not have troubles in future.
Yeah. No, thank you for that, David. And I mean, I always say to people, and I like the point that you've just made to say, when you draft a will, always play out how it would look like when administration takes place. And, I always say to people, much as we go to professionals, also do your study, understand your personal circumstances, do a bit of research. By the time you sit with a professional, from your perspective, you've looked at your own aspects, your personal aspects, and you're able to play it out. And as such, you are able to ask the right questions when dealing with the professional in drafting your will. So, colleagues, I think for me, this calls to action for us to look at, do you already have a will? And if not, that means this is a time for you to put your will in place. If you've got an existing will, we've had a lot of examples in terms of a will being put in place, but life circumstances changes and we don't review our will. We can never overemphasize. And the smallest thing that you could think it's a minor thing, the minute that life journey changes, it's important that you review your will. So I'd like to encourage everybody online, if you don't have a will, or if you do have one, make sure that you get it reviewed every year. We encourage all of you to contact our dedicated Wills Direct team to assist you with professional drafting and safe custody. I know Dylan has said that so many times, but we can never overemphasize that, so that you can save your loved ones and enormous stress and costs at a later stage. I think with that said, I just want to move to, the last part for me, just to thank our panelists for sharing their valuable information, the real life examples that they have shared with us, because I feel this is where we can start relating and see the reality of what actually happens post-death. So today we really explored what happens when the will go wrong. From poor drafted wills, unsafe custody, and how these mistakes can have an everlasting impact on families. But a will is only one part of the story, and it's important to understand that. Once an estate is finalized, the real question comes, how do you protect and preserve your legacy for a long run? And for me, this is where the trust services come in. And in the next and final session of the series, we look at how trust and modern estate administration work hand in hand to ensure that wealth and your wishes continue to support your loved ones in a well into the future. So we really look forward to part 3 of this, and it will be our final webinar where we're looking at future-proofing your legacy, trust, and the next chapter of estate administration. I think with that being said, I'd really love to open up the floor for questions. And I'm not sure on your side, Verity, do we have questions there?
We have a number of great questions, Sarah. The first one is for Dylan, and it's from Pamela. Please tell me what happens when someone has multiple wills, like with Absa and another bank.
Thanks, Verity. I think, again, very good question there, Pamela. So in South African law, only the most recent valid will signed by the testator is considered binding. If someone has multiple wills, the latest dated will, assuming it meets all the legal requirements, of course, is the one that will be used for the administration of the estate. So earlier wills are automatically revoked unless the newer will explicitly states otherwise. If the wills do contradict each another or cover overlapping assets, the Master of the High Court may reject one or both wills until clarity is provided, and this is often requiring court intervention, which then also could could lead to estate delays or estate administration delays, and again, more cost towards the estate.
Thank you so much, Dylan. Okay, the next question is for David from Joyce. If a married couple have a joint will and one passes on, can the surviving spouse decide to draft a new will?
Indeed, they can decide to prepare a new will if they so wish. If the joint will deals, usually when Dylan and his department prepare wills, they will, first part will be to nominate the surviving spouse as the beneficiary, and on death of the survivor, usually they would plan who inherits, usually it's the children. But if they also intend to make their own will, it's still okay.
Great, thank you, David. Right, the next question is from Margaret for the panel. She wants to know if there is any truth in the fact that it takes much longer to wind up an estate where the will was drafted in Afrikaans. Should she rather encourage her Afrikaans clients to draft their wills in English?
Thanks, Verity. I think I'll take that question. So, Margaret, there is no legal basis in South Africa that says a will is drafted in Afrikaans causes delays in estate administration. However, practically challenges can arise that may indirectly lead to delays, especially if the will is poorly translated, misunderstood by the administrator, or lacks clarity for non-Afrikaans speaking estate administrators. So to answer your question in full, there's no problem having a will drafted in Afrikaans, but just ensuring that your intentions are clearly stated in there. I would rather suggest having a will drafted in English just to avoid some of those issues that I just discussed a second ago. Thanks.
Thanks, Dylan. Okay, the next question is also for the panel. It's from Danae. In the case of the client who has a maintenance claim for minor children against his estate, how does the court view this against nominated beneficiaries who are independent children?
I'll take this one. Where minor children submit claims against the estate for maintenance, that it does not affect the nominated beneficiaries. It's treated as a claim against the estate, and generally the claims against the estate and any, for instance, it's on the same level as your vehicle finances, your bonds, all the claims that we need to pay. Usually when we administer an estate, we collect up your assets, publish a notice to debtors and creditors. That's how we'll receive most of those claims. And those need to be settled together with the estate administration costs and estate duty, SARS. When all of those things are settled, then we give whatever is left to the beneficiaries. And if those claims exceed the estate, then the estate will be declared insolvent and we'll be forced to sell everything and settle up all the debts. Have I answered your question?
Thank you, David. I think so. The next question is from Margaret. How is a will signed if someone can only do a thumbprint? Is there any extra info needed, or are the two witnesses sufficient?
Thanks. I'll take that question, Verity. So as part of our wills drafting, if a client had to sign a will, besides using a wet signature, what we would do in the will, include in the will drafting, is a commissioner's certificate. And what that basically means is that a commissioner of oaths needs to be present when that thumbprint of that testator or testator is placed on that will, just to verify that it was actually the thumbprint of the person making out the will. And this also, once again, has to be in line with the will's Act requirements, which means that that thumbprint must also be done in front of the two witnesses, including the Commissioner of Oaths. Thanks.
Wonderful. Thanks, Dylan. Okay, next question is from Krishna. How long does it take Absa Trust to execute an estate if the will was drafted correctly and kept in safe custody?
I'll take that one. We usually, in the past, we would take an average of 6 months. But now we have got a lot of dependencies that make it a bit difficult. For instance, we've got master's offices that are not functioning efficiently. We've got, maybe you find that we've even reported an estate and it's taking us maybe 6 months or so to obtain the letters of executorship before we can even start. We've got departments such as Department of the SARS department, they are also taking long to give us valuations, maybe valuations of businesses. And the normal tax assessments, those ones they don't take a lot of time. But where you've now got complicated tax matters and businesses, that tend to take a bit longer, because now we will have to be depending on those external departments to give us information. Clearance certificates for us to transfer properties are also taking us a month or two to sell, to enable us to sell those properties. So those things are selling or just transferring. So those dependencies have caused us to increase it a bit longer. There's some estates, I mean, we can administer them very quickly if there's really not a problem in the municipalities, or right, and it's maybe a Pretoria Masters High Court that does not have much delays. We have a smooth run with those ones, but some take us a bit longer because of external dependencies. Some other matters are delayed by maybe the lack of funds in the estate. For instance, maybe if we have got a cash shortfall where we are unable to pay the municipal costs. Usually we make a provision of a reasonable amount to cover for municipal costs, but you find that the family has not been maintaining that municipal account, and by the time we administer it, it's at almost 200,000, and no one has got money to pay that. It causes another delay for us. So it's a number of factors. But on our own, if everything is smooth, in 6 months we could finish.
Yeah, maybe before you move on, and I'm glad that David touched on that. Something that I always explain to people is, I know COVID is long gone, and we would love to believe that, we can't be speaking COVID, but the effects of that, with COVID, there was more deaths, and the system. And when I say the system, I'm not only talking about trust companies. David actually alluded to that. And in our previous webinar, we touched on that to say, who are the key stakeholders or players within the estate administration process? You get your heirs. The heirs themselves, if there is no understanding and working together and there's conflict, that in itself causes delays. Then you move to where we are now reliant on different masters. Different masters are we have the Pretoria and Johannesburg, which are much faster. We're having issues in Nelspruit and in Mbombela. So depending on where it's administered. Also, if you have multiple assets, and depending on the complexities of those assets, we're dealing with the deeds office, the transfer, we're dealing with lawyers. So all of those things, if it's a car, as well as that, we're dealing, and David alluded to municipality. So I don't want to repeat myself, but I think the one thing that I always want to put is that we shouldn't forget that, with that backlog, much as it's gone down, the system was never ready for so many deaths. And it's only now that we're looking into that, different companies and including government departments, where they're looking at various ways of how do we deal with higher volumes. But yeah, I'll leave it at that. But I think for me, it was important to put that factor in to say, even if internally we are done with our processes, if we are depending on a lawyer to transfer, or depending on a deeds office, or depending on municipality, or depending on the areas where there's conflict or shortfall, that in itself delays the process. Thanks, Verity.
Thank you for the clarity, Sarah. Right, we've got another question from Krishna. If the instructions in the will is to sell assets, will they be sold at auction or at market value?
I'll answer that one. The best is to sell them at market value. If it's an immovable property, we'll appoint estate agents to sell it. And should we, maybe if it's a distressed property, or we are really struggling to find a buyer, we've got auctioneers who have advised that an auction is a different one, because people who attend auctions come there with money to buy, and it's usually a different kind of market. It's usually investors or people who are in the business of maybe repairing properties and sorry, let me just sorry. Or it's people, all the people who attend an auction, you are guaranteed a sale, and it's just an issue of how much it will go for and if we agree.
Great, thank you, David. Okay, Danae raises an issue that clients are unaware of how to sign wills. She just asks for some clarity on this matter.
100%. I'll take that, Brady. So with every will that we send out after drafting, we do include documents in regards to how a customer or client should be signing that will. But also very important, again, that we do have qualified professionals within our business to assist our customers with the signing of their will, should it be questionable or unsure in terms of how they go about signing it. So I think the bottom line being is that if there's any confusion around how they should be signing a will, always reach out. At Absa Trust, we do offer the services of qualified professionals to assist you with that signing of your will. Thanks.
Thanks, Dylan. Okay, Jonathan asks if there is any updates on digitally signed wills.
I think I'll take that as well, Verity. So, interestingly enough, on the 1st of August this year, there was a High Court ruling in a case it was called Mongoro NO versus others, where the master did accept a 2021 electronically signed will of the late Justice Yvonne Magoro under Section 2, Subsection 3 of the Wills Act. So despite its non-compliance with the formal requirements of the Wills Act, so remember it has to be a wet signature, the court highlighted that there was a clear evidence of her intention, including an email instruction and witnesses' affidavits confirmed that the document reflected her final wishes. So as much as right now the act has not changed much, it still requires a wet signature. I think this particular case does highlight the importance of us moving into that digital era where the master is obviously looking at other ways where a customer or a testator or testatrix could actually sign their will. So yeah, I think we this does set a precedent in our law, and it does guide us. And again, we'll just wait for updates from the master or or any changes in the legislation going forward. Thanks.
Thanks, Dylan. Okay, Margaret asks two questions. If there is no commission of oath, if the commission of oath is not available, is the will illegal? And your follow-up question is, should we give them the will to go have it signed somewhere else?
Again, I don't think it makes it illegal, but it does create complications. Then it'll have to go to a court process for it to be then verified as the last will of the testator making it out. Making out that will. And again, it just delays the estate administration process and adds more cost to it. And then, sorry, Verity, the second part of the question was?
Apologies. Should the will be returned to be signed somewhere else?
Yes. So again, having that commissioner certificate is very important. We do assist with that certificate when we draft the will, and then we do have commissioner of oaths part of our business at the different Absa branches. For example, the branch managers are commissioner of oaths and can assist with the signing of those wills as well. But you do have various options. So you can go to an attorney, you can go to your nearest your police station to be assisted. Alternatively, I also do believe that post offices also do offer that assistance as well. Thanks.
Okay, Nontando raises an issue where documents were submitted and mentioned that Absa would request them again after months and say the documents had expired. Is the fault with Absa or the masters?
Dylan, let me take that on. When we submit maybe documents for anything, maybe we submit them to a department, maybe to the banks or to a certain maybe a certain creditor that maybe the beneficiaries have advised us that maybe the deceased had some investments there or something. We always have to renew the documents. They need to be certified, not more than 3 months old. Even maybe vehicle transfer documents, if we prepare them and courier them to the beneficiaries and they receive them and then don't do anything with them, when they take them after a year, we need to have them recertified. So they need to bring them back. We recertify them again because we're in possession of the originals and give them documents again. I think it's just an issue of efficiency. It's not incompetence on our side.
Okay, Ketsile says, excellent session. Can we touch on your experience with wills that have family members appointed as executors instead of a reputable company like Absa Trust?
Thanks. I'll take that, Verity. So again, just to avoid any disqualifying of beneficiaries or heirs, or even an executor, it's always important to appoint a third party, I think, to handle the administration of your estate. When it comes to the Master of the High Court as well, the Master will always ask if the person appointed as the executor has the experience to administer the estate. And I think that's also quite an important point. So if they don't have that knowledge or of how to administer a state, then they will always require you to go and seek a qualified professional to assist you with the administration of the estate. So again, appointing family members can actually lead to delays in that estate administration as well. Thanks, Verity.
Mhm. Thanks,
And
Verity.
another thing on that point, I've seen some things on social media where people have been suggesting that people have their family members as executors. The thing with state administration, it's actually it's not as easy as it looks. Someone may just think, I'm going to be the executor, I'm going to collect the monies. It's not that. You need to account to a lot of parties. For instance, SARS, for one, you need to account to them. If there's business in there, you need to get proper valuations. And if you do not know where to get that information, you would not know. You need to have valuations issued by SARS, valuations of businesses. And many times, and I've never seen any family member who has managed to administer a estate. What they do is collect monies from the bank accounts, use the money for purposes that they are not intended for. And years when they've reached a deadlock, they come to our offices and we have to rectify all those mistakes. I've seen it many, many times. It's a professional thing. You need to, I mean, we this is our profession. We render services in administration of deceased estates, so as much as other trust companies. And it's not like someone is going to save money, because whoever is going to assist you in administering that estate at a later stage is also entitled to the executor's fee of 3.5% of the value of the estate. I think the reasoning of trying to appoint a family member may have been based on trying to save costs, and I think it rounds us to the same thing.
Yeah. And just to add to that, I mean, the whole process is governed by so many legislations, so many. With all those complexities, if you don't have that knowledge, it just prolongs the process. You need to go find somebody. I sat with a case where there was a complaint, and unfortunately, the family member, to David's point, they started chowing the money. They didn't have the best interest of the heir in place. And yeah, it ends up being a horrible place, as a space for the ones who are left behind, because of people just put their needs before. Or sometimes they would say, to David's point, no, rather use attorney firms. And we are not saying there's something wrong with attorney firms. We're saying if you do choose to use attorney firms as your executors, it's also equally important to check, is it a one member? Because if then that attorney firms, we landed with a case where an attorney firm passed on, the files were sitting there, nobody could administer. It just took so long and some things were not resolved. So there's a lot of risks. I think for me, it's more about, do you ask the right questions if you want to choose an executor, but understand that this is really a professional and very complex process that requires somebody who's got the knowledge, who understands who the stakeholders are, and are able to go through the process.
Thank you, Sarah. Right, our next question is from Samanda. For clients who have special needs children, how should you draft a will? Is there a specific trust?
Thanks. I'll take that, Verity. So it was mentioned in one of the pitfalls when it comes to the drafting of a will, just to ensure that you have the right structures in place to your specific needs. So again, for children who have special needs, a testamentary trust is then a good solution to have in place in your will to look after the needs of your child that has those special needs. I would always maybe suggest to that specific person making out a will in these circumstances to appoint a co trustee with this trust, who's a family member who then obviously can serve as the in-betweener between the trust company as well as the child with the special needs. So they can just ensure that that the trust and the funds itself is administered correctly for that specific child, as well as ensuring that the testator or testatrix needs was met in terms of what they required for that child. So yes, thanks.
Thank you, Dylan. Vincenzo asks, what is the required period for reporting a late estate so that Absa will accept and wind up the estate? What is the cutoff time to report the late estate?
There is no cutoff time for reporting an estate. It's just it's advised to do it as soon as possible. As soon as someone passes away, notify us and report the file with us. So we even sometimes even check whether the person has got a will with us or so. Usually we find out from the branch where the family members go to the bank and try to get money for a funeral. That's where we catch wind of it quickly, and we start looking around and asking questions about all of that. But they should bring it as quickly as possible. But there is no fixed timeline on it. It can be reported after 20 years, it will still be administered. But the problem with staying longer is that information gets missing, people pass away, and it ends up being an estate that we're unable to administer.
Yeah. And Verity, if I could just come in there, some of the mistakes that I find that we do, and this is where we need to educate our clients. When you go to the bank and report that somebody has passed on, usually they report for closing of accounts or they want a funeral policy. It's quite important to understand there's different processes that you can report to get a funeral policy or to claim your funeral policy, or you could be reporting because you're closing a bank account. But there's a different process for reporting death for estate administration if the will is with us. And it's important that when you do go to the branch, you ask them and tell them that I want to report death for estate administration purposes. So they will be able to cover everything where it's closure of bank accounts, if there's a funeral policy that you're trying to claim, but the matter will then be brought to our intake center. I've sat with one matter where it stayed for 2 years and the client was complaining that they reported, but in essence, all they did was to go to the branch and say, my mom had an account with you, and the branch closed the account, but it wasn't the actual reporting of the estate for estate administration processes. So that we need to get right as well.
Thank you for that clarity, Sarah. Okay, Margaret says, the process of signing an overseas will for a South African citizen is very long-winded. Can it just be signed and returned by courier, or could it perhaps be signed digitally?
Thanks. I think I'll take that, Verity. So, Verity, as mentioned before, there are requirements in the Wills Act in terms of how do we go about signing wills. And then one of the requirements is that if a will is signed abroad, that it has to be signed and witnessed at the local South African embassy office. And then obviously stamped by that, or a notary stamp is then required from that embassy office to validate that the will was signed at the embassy. So I know this process is long-winded, and I appreciate that there's a lot of admin involved in that process. But once again, we as a trust company, we have to ensure that we are following the letter of the act, so that will is then validated, and so we can act as or administer that estate accordingly on death. Thanks.
Thank you, Dylan. Okay, we're touching on family members as executors again. Krishna asks, if the client appoints a family member as a co-executor of the estate with Absa, what is the role of the family member as the co-executor?
I'll take that one. Their role as a co-executor, usually we will request that they give us a power of attorney so we can administer the estate on their behalf, because it will be very impractical to have maybe if they need to verify me and verify the co-executor at the same time, it makes it very difficult for us. We'll constantly require them to come to the office to do something, or let's go to the bank, we need to sort this out, and they require all the co-executors and to check them. Just for operational purposes, we usually request them to give us the power of attorney to administer it. It makes it much easier, but we'll keep them updated on all matters. as it moves. But if they so wish, we can, they can come and sit with us here and run with us through the process. Whenever we sign documents, they also sign on their part. It's just an issue of convenience.
Perfect. Thank you, David. Tumiso asks, what other original documents are filed with the will? I often hear clients asking for car documents and title deeds.
The documents that we will require the death certificate, the original, the ID. The vehicle documents will also require the originals. The title deed will also require the original title deed to enable us to do the transfer to the beneficiaries who must inherit. We request the originals to enable us to certify those documents from time to time. We'll usually return them back to them after we've completed the administration process. Because of the way we certify documents to send to different departments and also accommodate the expiry of that timeline I explained previously, it's important that we keep the originals and we hand them back when we no longer need them.
I think I'd just like, sorry,
Sorry?
Fred, just to add on to that, as part of our will drafting process as well, and some of the supplement documents that we provide our customers with when we return their drafted will is just having a list of documents that is required for administration on death. And what we normally advise the clients to put into place, well, actually part of a pack, we have a folder called a family legacy folder. And it kind of points out what documents are required at the time of administration and kind of guides the customers as to what documents they should be actually storing in a folder, just to ensure that they make that administration process a little bit easier for their family members. Thanks.
Thank you, Dylan. Charity asks, what happens in the event when the client used Absa colleagues as their witnesses? The client passes away and the family is disputing the will, and the Absa staff that witness for the client are no longer employed with Absa.
Okay, thanks, Verity. I think I'll take that as well. So, Verity, well, if an Absa colleague does witness a will, it doesn't invalidate that will. And if there is any court application brought against that particular will in terms of disrupting that will and making it invalid, it will obviously have to follow the court process to ensure that that will is then determined by the court to be a valid will for the master to accept. So I don't think there's a straight answer to it, but it definitely does not disqualify a Absa colleague from signing a will. If there's what I'm trying to say is that if there is any issues regarding the signature or witness signatures on that will, then it'll have to be referred to a court, and the court will then determine after it initiates its processes whether that will is valid or not.
Thank you for clearing that up, Dylan. Okay, Margaret asks, is it allowed to delay the reporting of the state when the first spouse dies until the second spouse dies due to no funds, especially if the only asset is the property where the spouse is living?
I'll take that one. It's not prohibited, and I will not say it's permitted, but if the immovable property is the only asset in the estate, and you are unable to do the transfer because the surviving spouse does not have money to cover the transfer costs in the municipal accounts, it makes it difficult for us to continue administering the estate because there is risks involved in holding on to an estate. Firstly, the master requires us to administer an estate within a certain amount of time. For instance, we need to submit a liquidation and distribution account within 6 months. Now, whenever we do not submit it in 6 months, we have to write to the master and request an extension of time. It's something that we do on the side to enable us to administer an estate. Maybe if we put to 2 years, every 6 months, you're guaranteed a letter is going out. But to avoid the risks in such matters, sometimes it may just be advisable for the executor to resign and perhaps appoint the spouse to be the executor so that they can be liable for any risks that comes there, because there is debts that accumulate interest. For instance, if they've got maybe a bond and it's not being serviced because the surviving spouse does not have money, it's a cause for concern and it's going to be dealt with by the creditors. They will end up submitting suing you for maybe even foreclosing against the estate. If ever the executor delays without good reason, and it's not good reason to say they do not have money. The next thing to do if you do not have money is to liquidate. It's an act of insolvency to sit with an estate and say, I'm going to wait until I die for the property to be sold. So it puts a lot of risks on the executor, and the advisable stance would be to resign so that we are not party to the trouble that comes with the insufficient funds. And there is provisions that our wills drafting department have. They've got policies in place that enable you to liquidate your estate. Estate provider plans. I've got one myself. I think it's covered me for 300,000. If I don't have money and I can't administer my estate, such things may assist you in that. It's important. It comes to the estate planning and the guidance that comes with you preparing your will in the first place to ensure that you've got money to cover for such things.
Yeah, very critical point that very shame. We need to give you a break. I'm sure you need to breathe a little bit with all these long questions. So if I can just come in and help you out there. So the next question is from Carl. It says, what is the cost or percentage to set up and run a trust? What are the yearly fees and etc.? So maybe I'll just start off there, and I'm not sure if my colleagues have an answer. If you remember, we had indicated that the next webinar is really going to deal with the aspect of trust, because there's different type of trust that apply, and as a result, the different fees would apply. But I think for me, I would advise that you join the next session that we're gonna have, so that you really get an understanding what are the different trusts that we have. I mean, we look at testamentary trust and so on, and there's different trusts created for different reasons, and the different fees would apply. But I'm not sure if Delon, you want to add anything, but I would strongly recommend that you attend our next, because that's where the details and where we're going to have the trust experts join us there.
100%, Sarah. I agree with you on points. There is different costs applied to different types of trusts. I think it's best to clear that up in the next session. Thank you.
Okay, and I see the follow-up question. It says, is the testamentary trust still appropriate if a special need child is a major?
Yeah, Sarah, I think again, a testamentary trust is still required for a special needs child, and I think it boils down to the fact that puts a specific child with those needs, whether major or minor, still doesn't have local standards, and or can't make certain decisions for themselves. So they would need a testamentary trust to guide them in terms of how those funds should be handled and what it should be used for going forward. Thanks.
Great. We've got a comment from Christina, not necessarily a question. Very informative session. Thank you for answering my questions. And then Dumiso is asking, he says, I was asking for the safe custody just after signing the will. So I'm not sure what the prior question was there, but I'll try and link it. Maybe let me just go to Christine's question, and then we'll take that. So how practical is the living will clause in a will? Will the clause in the will be accepted by a medical doctor to execute the client's wishes?
Okay, I think I'll take this one, Sarah. So currently a living will is, there's no legislation in South Africa that deals with a living will. So there's no legislation guiding us as trust companies in terms of a living will, and to be quite frank, there is a living will is not recognized. In other words, to have a living will as part of your will just merely gives a suggestion to your family members in terms of how they would like a certain circumstance or situation to be handled if they aren't able to make those decisions on their own. It is up to the doctors and the family members, obviously, to make that decision at that point in time. Thanks.
Right. Thank you, Delon. I see Dumiso's initial question was around what documents need to be filed with the will at safe custody. So I think Dylan had already answered that with the will, it's just with at safe custody, it's the will itself, but you need to keep your own file. And I think Dylan spoke about that, the legacy file where you keep all these documents. But I'm not sure if Dylan, there's anything else that you want to add there with the will. Are there any other documents, or the main document is the will?
It's the main document is the will. What we also include as part of Absa Trust is the debit order that we require to be signed, and that's for the deduction of the safe custody fees which we charge. It's a minimal amount. It's 100 Rand per year. And if you add VAT into that, it actually works out to 115 Rand. But I think what was also mentioned is that we do have a really great policy called the EPP policy, or the instant life policy, that deals with liquidity issues in an estate. And we do have a partnership with our with Absa Life, that if one of these policies are taking out, then you do not actually pay those safe custody fees. So it's almost encouraging the customer to take out that policy, and you obviously avoid paying extra fees on your safe custody of your will.
Yeah, and I'd like to encourage everybody on the line just to find out about the legacy file. It is quite a critical file. I mean, I've done that. If I can just give an example with my daughter, I've got a file where I've got a list. It's a spreadsheet. It's got a list of all the important people, my medical doctor, the lawyer, the financial advisor, and so on, and all the other relevant documents. But it guides you on what those documents are. It really makes it easy at death. So the next question, I'm hoping that I'm not repeating the question, from Vuyi. Do the witness need to be members of the family or even beneficiaries themselves?
Thanks, Sarah. I think that was mentioned previously in my discussion. So if you have your beneficiaries signing as well as witnesses to a will, then it does disqualify them, and it could invalidate your will. So I would avoid going down that road. My suggestion is always to get that legal guidance, approach qualified professionals to guide you and assist you whether certain witnesses would be disqualified in terms of signing a will. Thanks.
Right. A note from Jenna Smith. Thank you so much. This was such a practical session to be part of. Thank you for your time. And then Margaret comes and wants to know the minimum amount for a trust. Again, Margaret, I'm going to advise you, because as we said, there are different types of trust, and depending on the trust, the fees may be different. So I'd love to encourage you to join us for our last webinar. Philip, so much I am learning on a practical level. I will now be able to deal with real life issues in the subject matter. Great. Well done for you, Philip. Christina, can a client, so a question from Christina, can the client sign a living will by itself, dated and signed by witnesses? Will that then be a valid and accepted?
Again, Christina, living wills are not recognized under South African law. So yes, it can be dated and signed by the person drawing it up, as well as witnesses. It can give much intention to what the specific person would have wanted in those circumstances. But again, it's not a valid or recognized document in South Africa.
Great. I think we've come to the end. It's just a last comment from Reneswari. Thank you everybody. Oh, I have to go see a client. So that was just the last note there. I'm glad from my side, colleagues, that you found this to be more practical. Oh, Christine is back again with the question. Let's just go through that. How would you deal with an estate whereby the deceased left the assets to her brother and the usufruct of the assets to the spouse? The spouse is critically ill and stays in a home care. The brother lives overseas and wants to sell fixed property. David, do you want to look at that?
Yes. If an usufruct is left in favor of the spouse, an usufruct has got a value of its own. So if there's a way that there's a graph that we use to calculate that value of it. So it determines the value of the estate. Either we can, or if both parties agree to sell, then the surviving spouse would have to sign off. I think that it's a notarial session of some sort that relinquishes that right to the usufruct. But if not, then we cannot proceed. That usufruct applies until they pass away.
Great. Thank you so much. Christina Brits, question, will Absa execute an estate below 500,000? The answer is yes, we will administer that estate. Great. So we've dealt with the questions, and I'm glad that we were able to answer most of the questions today. We normally have a lot of chat and not be able to get through to all the questions. So I just want to thank Verity, you and your team for really an excellent job in putting this webinar together. And also our brilliant panelists, Delon and David, really gave us practical examples of how to make sure that you've got a properly drafted wills. We've seen the different examples, and the next step is for us to take things into our hands and make sure that we get the wills properly drafted, have them safely saved in safe custody, and hoping to see most of you and invite more people for our next webinar, where we will be looking at trust, how trust and modern estate administration work hand in hand to ensure wealth and your wishes continue to support your loved ones well into the future. Really looking forward to that. And that's we've come to the end of the webinar. Thank you to everyone.
Thanks, Sarah. Thanks, Dylan.
Thank you so much.
Thanks, everyone.
Thank you. Bye.
Bye.
Thank you.
Bye.
Bye.
Thank you. Bye.